meeting is being recorded.
Okay, well, welcome everybody to this presentation by Professor Cathy Douglas from RMIT. This is the first presentation after our brilliant keynote by Professor Bernie Meyer in a series of presentations for the online version of the 2022 ADR Research Network Roundtable. So welcome to you all, and I'd like to begin by acknowledging the original custodians of the land where Professor John Crowe and I are coming from, and also Professor Lawrence Bull at Bond University, which is the Kombumerri Saltwater people of the Yugambeh language group, and pay our collective respects to First Nations people all around Australia and indeed around the world. So just to introduce us, Professor John Crowe and I are the conveners of the ADR Research Network for 21-22 and the conveners of the Roundtable. And we were delighted to sort of find an alternative way of having the Roundtable go ahead despite, everyone's capacity being a little reduced. So it's great that we're joined today for Cathy's presentation by some stars of the ADR Research Network, Lawrence, Becky and Margaret. And at the end of Cathy's presentation, we'll be engaging in some discussion around the issues that Cathy raises. So the title of Cathy's presentation today is Lawyers' Practice in Mediation, Including Emotion as Part of Lawyer Guidelines. And just a brief introduction about Cathy, because I'm sure she doesn't need much of an introduction, so well known, but Cathy is now very busy in an executive role as the Dean at RMIT of the Graduate School of Business and Law. Did I get that right? Yeah. She's been just a long friend of all of us in the network and is indeed a founding member of the network and was at the very first Roundtable in 2012 and has been at almost all of them ever since. And Cathy has also been a great contributor to ADRAC, which is replaced NADRAC, which was very dear to all of us. And up until 2019, Cathy was a part of that, which is another important aspect of the dispute resolution community in Australia. So I would like now to hand over to Cathy, and we're very interested in hearing what you've got to say, Cathy, and looking forward to responding to your comments afterwards. Thank you.
Well, thank you, Rachel and John and everyone who's here today, but also, of course, who might catch up later in the recording. And I would also like to pay my respects to the Aboriginal people on the land that I am presently on, which is the Wurrung and Boorong people of the Eastern Kulin Nations, on whose unceded lands we are presently holding our meeting, and also acknowledge their ancestors and elders past, present and emerging. This paper, like other papers that I presented at the ADR Roundtable, is still very early stage. It's a summer project. I didn't know whether I'd get it done. And what is marvelous, I think, about the Roundtable is that it gives you a deadline and that you do endeavour to meet the deadline and perhaps something comes of it. And I just wanted to give a plug for the Roundtable, which is such a great part of the ADR research community. And the plug I would give is that the other papers I've given in the past have all ended up in publication down the track. It took some time with some of them, but they certainly have assisted me to publish. So I really encourage others to do so. My paper today, and I'm not going to use slides, I'll have a conversation with you, really comes out of many years of work in ADR research. It comes out of my thesis where I looked at legal education in ADR and explored emotion in the teaching of ADR. It comes out of some studies I've undertaken collaboratively in relation to ADR with both mediators and lawyers. And it comes out of my own mediation practice over many years, where I observed the place and the impact of emotions in dispute resolution, particularly in the process of mediation. where lawyers were present and where lawyers weren't. So today the focus is upon lawyers and is, as the title suggests, also on the Australian Law Council guidelines for lawyers in mediation. So when we think about lawyers and dispute resolution, in the past, a dominant discourse has often been that lawyers are adversarial in their engagement with court processes, and sometimes, in fact, some commentators have argued always, lawyers transfer a litigious mindset to the mediation room, and there is therefore the potential to stymie settlement and not meet their clients' needs. And that, I think, has been a dominant view for many years, and to some extent might well have been true for a variety of reasons, though. It might be that lawyers have seen mediation as a potential settlement opportunity, but also fear their clients saying too much or being inappropriate in their view of what to say that might interfere with the strength of the case and therefore an advantageous settlement. They might see emotion as part of the narrative of the mediation as inappropriate because the rational discourse was more important to legal problem solving, that the frame of engagement for the lawyer in the mediation was centered around whether there was a legal issue that had merit for the client and how much potential damages or other kinds of redress were available. So in the early days of lawyers' practice, it might be said that they were not practicing non-adversarial justice, that they weren't engaging with the opportunity of mediation and furthering collaborative problem solving through dialogue, creative problem solving, through engagement with their clients' non-legal needs as well as their legal needs. And some studies, both overseas and in Australia, have shown us some of the experiences of mediators and lawyers in mediation that I think are very valuable and can lead us to think, how can we better support lawyers to engage in non-adversarial constructs of practice, but that also include emotion. Now, emotion is something that many of you as mediators and lawyers have experienced in your practice. And some argue that emotion is always part of conflict and that there are physiological, cognitive, psychological aspects to conflict that impact on people engaged in problem solving like mediation. My own experience as a mediator is that nearly always emotion was part and parcel of the process. And it may be that in a wills case that you're mediating, people have a very real and emotional response to discussing options in an estate. It might be that in a commercial matter, even though that they might not be as personally invested as in a context such as a will, but still emotion might affect their framing of how they engage in the mediation, because they might feel that their status is lowered, or they might feel resentment or anger towards a business partner, or even they might feel that a positive emotion is in the room. So they might be able to see through the process of mediation, through creative problem solving, a hopeful and engagingly positive outcome. So if we say that emotion is frequently, perhaps not always, but frequently part of dispute resolution, if we say that mediation has a special part to play in party engagement, and if we say that lawyers can be part of that journey of engagement, how can we help lawyers to see how best to practice in mediation with the specific issue of emotion? Now, there are a few underlying premises to that. First of all, that there's value in emotion being part of a mediation. If you are able to deal with the underlying issues and concerns of people, we've long argued in mediation that that helps settlement and can lead to a more beneficial, holistic outcome. Emotions can point to what is important to a client or party in their underlying issues and concerns. In a study that I undertook with several co-authors, we looked at mediation practice from the perspective of mediators at VCAT, and one of the people I published in relation to this study is here today, Becky Bactigol, and we specifically looked at lawyers' roles and practice in mediation through the eyes of the mediators, which we published some years ago now. But I'm also going to more particularly look at a paper I wrote with Tanya Claire Coburn, where we asked those mediators what they did with emotion in the room. And they talked about the importance of emotion. They nearly all agreed, I think they all agreed that emotion was part of conflict and entered the mediation room. And in that study, some allowed mediation and some encouraged mediation. The ones that encouraged it argued that it helped settlement by allowing all the issues to be discussed more fully, but also gave the parties the opportunity to tell their story, to be heard and validated. Now, in that context, procedural justice is an important part of practice in mediation. And Lawrence Bull is here. I can still remember reading Lawrence's writing in one of his books, early edition, where he talked about procedural justice. And I was immediately taken with the idea and felt just from my own mediation practice how important procedural justice is. And we know from Tyler's work that the psychological impact of being heard and validated in a dispute resolution process can in fact assist people to accept an outcome, whether it's good for them or not necessarily. Tyler's work predominantly has been in relation to courts, but there has been some work in relation to mediation as well. And what I found very important is that if we look at procedural justice and having voice and validation in a process, and in the facilitative model, being given the opportunity to put a party statement that tells the story of the conflict from a party's perspective, if we look at that, we have to, for a respectful process, I believe, I would argue, include emotion, that we can't cut our parties off and constrain them to this dominant discourse of the rational, which legal people have traditionally imposed on much of mediation practice, that we need to allow and encourage emotion. And the lawyers in the room are so important to achieve that outcome, because it's their advice, their facilitation of the client's needs that can either allow emotion, can encourage it even in some circumstances, or suppress it. So I see procedural justice and emotion as really two parts to the same story. Now, what I particularly am focused on in this paper is looking at these studies, and I'll talk about a couple more now, in terms particularly of lawyers' practice. Tanya Sordine, in her evaluation of mediation in Supreme and County Courts in Victoria, some time ago now, but still I think a very powerful study, showed that many lawyers were the dominant voices in a mediation, that what they tried to do was to bring their traditional adversarial constructs into the room. And she makes the point that a lot of what happened in the process really was more about what suited the lawyers and the clients. And this echoes Relis's work in the UK, where she makes a very strong argument from her empirical work that lawyers dominate in the mediation process. That study, I think, is complemented by Olivia Rundle's work in Tasmania, in the Supreme Court of Tasmania, where she found the lawyers tended to ask the client not to speak, that they wanted to control the conversation, mainly for the good of the client in trying to protect the ways that the issues are discussed so that they could get the best outcome, and followed a more evaluative or settlement option in what they were trying to achieve. More recently, a doctoral student of mine, Tina Popper, published a paper, and I was part of it, on the Monash Law Review about torts lawyers in medical negligence disputes. And in that study of 24 lawyers, the mediation was not focused on emotional or non-legal concerns, but the mediations, according to the perspective of the lawyers interviewed, were more about an advantageous financial settlement. And this was compounded by the fact that the insurer was present rather than the doctor. So there was no real opportunity for an apology, for instance. But there was a genuine concern from the lawyers about the well-being of the parties, that there were clients, and that they wanted to assist them in terms of the emotional cost of litigation, so that they hoped for an advantageous settlement to the matter at mediation. An interesting study that I've only just written up, happened in 2016 with my co-authors Robin Goodman and Anne Kellys, dealt with lawyers and planners in the planning jurisdiction. We began this study interviewing 17 planners about their experiences of conflict, and then continued the second phase with 12 lawyers in the planning jurisdiction who gave their perspectives on mediation. I'll just say that the planners talked about mediation, but we're really also talking about conflict at the very first stages of the planning process. And I'll also say that the actual lawyers were also engaged in compulsory conferencing, which was a similar process to mediation. But what was really interesting about that study is they fully embraced emotion. The majority of those lawyers interviewed in the qualitative study, and wanted to give validation and voice to the objectors engaged in the mediation or compulsory conference process. They saw it as important for their views to be heard, and that they sympathised with them about the complexity of the jurisdiction and the impact of the changes to their built environment by the proposed planning changes. So in that respect, it was a very real and engaged effort by the lawyers involved to not only engage with emotions, but provide voice and validation in terms of a procedural justice. So that last study in particular has given me the inspiration for this paper. And this paper is saying the lawyers are, in their practice, framed, if you like, by the Australian solicitors' rules, their ethical requirements. But those ethical requirements are quite limited. And here, of course, we look closely at the work of Bobette Wolski, who's analysed this in great detail and makes the point that really the ASR don't give us a lot of guidance in mediation, that it's a transfer of what could be in the courts. But the LCA guidelines, the 2019 version in particular, do give us a lot of guidelines. I would argue the guidelines provide a framing of non-adversarial practice. Problem solving is privileged and endorsed. Interpersonal skills that might assist collaborative problem solving are endorsed and persuasive argument. And in fact, in the 2019 version, there's a very explicit endorsement of the ASR rules and the ethical framework for lawyers' practice in mediation. But what is missing for me is some hint of how to help lawyers with emotion. And given that these guidelines, although are non-binding, can have a normative influence on practice, I think it's important that they change. And I have suggested in the paper that where, for instance, pre-mediation is discussed, it could be possible to alert lawyers to the importance of exploring emotions that might assist with uncovering the underlying issues and concerns. That also pre-mediation might be a good opportunity, according to Shapiro, to engage with emotions so that it isn't sitting always in the process of mediation itself. I think also we can look at the personal, commercial and business aspects of the client's needs as inclusive of emotion. These are included presently in the LCA guidelines, but they could be expanded to include more explicitly the emotional context of conflict. I also think that within the mediation itself, that the lawyers can use the literature of mediation to both allow and encourage emotion where appropriate. They can use the skills that mediators have identified in various studies and articles relating to reframing, summarizing, engaging with emotions such as anger. There are skills and approaches that have been identified in the mediation literature that could be valuable to lawyers to really engage with. And also, of course, I think it's really important that legal education becomes part of the conversation. How can we prepare lawyers of the future better to engage with emotion in mediation? An early study from my thesis did establish, and I worked with Becky on this one too, that ADR subjects do include emotion in relation to communication skills and role plays in the debriefing. But if the LCA guidelines were updated to more explicitly include emotion, it might provide law teachers with the inspiration to also more expressly and more comprehensively engage with emotion. There's a lot of literature about emotion now, neuroscience included, so there's a lot more we can do in this space as ADR educators, particularly in legal education. And finally, I would say it's low-hanging fruit. What do I mean by that? Well, these guidelines are, I think, significant, although non-binding, but changing them is not like changing the ASR, the Australian Solicitors rules. It is a much softer approach to including emotion in lawyers' practice and legal education, and therefore provides us with a real opportunity for change with less resistance. And I think as we move to a more sophisticated practice in ADR, it's one of our levers to improve that practice and also ultimately to improve procedural justice. Thanks.
Thank you so much, Kathy. As a busy executive dean, how you have time to maintain your research portfolio, I do not know, but you are amazing and an inspiration to us all. So thank you so much for that, and so much for us to talk about with question and answer. And I just, I couldn't agree with you more in terms of everything that you've said. But I'd like to give the other members of the ADR Research Network who have joined us today an opportunity to be part of the discussion. So open it up. Margaret, Lawrence, Becky, who would like to ask a question? Margaret's got her mic off, so over to you, Margaret.
Oh, it's off. It's on. Good. I completely agree with what Rachel has said. I find fault with nothing that you've said, and I think it's really, really on point and so important. And I just have an observation, which I think sometimes does lag a little bit behind in trends. One of the issues that I've been encountering and dealing with practitioners with is that there's a tendency for the mediators to be drawn from a pool of senior barristers or retired judges. And they tend to approach mediation a little bit more along the lines of a shuttle negotiation than an integrated, facilitative, broad mediation, which what we would understand mediation to be. And I've just been quite frustrated, and I think a number of my colleagues are quite frustrated by the fact that movement forward into the sort of realm of adapting to feelings and integrated conversations and everything that you're talking about seems to be, I think, a little bit stymied by the approach of the mediators. So we almost have people who are in the profession, many of whom I've taught, of course, who are butting up against the idea we'd like a mediation, but they're finding what's on offer, or perhaps the tendency to select a certain type of mediator doesn't always enable that to happen. And I have no idea what the answer to that is. I would be grateful for any insights because it's a bit frustrating.
Yeah, and I totally agree with you. And that's the disconnect, isn't it? We're all teaching facilitative models of mediation, and then they go out and it's evaluative or shuttle negotiation. And I actually called this out in my thesis in long ago, that maybe we should be teaching evaluative mediation as well, because we're privileging one model that is not really being practiced. But on the other hand, we do have VCAT mediators in the study that Becky and I did who were quite adoptive of the facilitative model. So I think it's varied out there. And of course, we know family law is a very distinct area of practice, which does engage with emotion and a non-adversarial approach in line with a facilitative model or even a therapeutic model. So I think there's just such a range of practice. There's a really great article by McHugh in the ADRJ, where he calls out the tendency for mini trials in mediation and asks all of us really to be advocating for a different approach. So I think there are really senior people there who are advocating for this, but it's a journey that's still to be travelled.
Yeah, great. So Becky, you're a very well qualified person to engage in this discussion with Kathy, considering you're both co-authors on the topic of emotion. What would you like to add?
Kathy, that was great. Really enjoyed seeing you look at this issue, because I totally agree that I think it's absolutely central to not only good practice, but good outcomes for clients. I'm interested in thinking about, and you were talking about, I think, was it the Law Council of Australia's guidelines for lawyers around mediation? And I just didn't quite get time to look them up before I asked my question. So it's a genuine question. You say they talk about interpersonal skills, why is that inadequate? Because my way of thinking is that interpersonal skills probably do include the necessity for lawyers to engage with interrogate their own emotions and their clients, or at least their clients and then their own, and to have some level of emotional intelligence, EQ. Of course, not every lawyer will be able to do that, and we know from experience that there's a variety of practice around that. Why do you think there's a need for more than what's already in there?
Well, I think the comment section on Rule 4 talks about before a mediation, a lawyer should, as well as assessing the legal merits of the case, consider the dispute in commercial terms, and in light of the client's business, personal and commercial needs, generate possible practical options for resolution. I think it isn't very comprehensive of emotion, given to the amount of literature now saying how central emotion is. What I would argue it does is just more or less leave the usual constructs of the rational dominating over the emotional in law. It sort of talks more about practical problem solving than really engaging with emotion as such. And we know too that if this is a possible norm setting document for the profession, being a bit harder hitting about emotion might help with many of the issues too that Margaret's been raising. I would also say to you that some part of the paper that I've kind of left out due to time is that there's actually a real recognition for judges and emotion. And you possibly, I think, would know this work, Becky, with Sharon Anlou and Kathy Mack. They've written a lot about this. There's a recent book. And they're talking about, for judges, how important it is for them to deal with emotion, that they need to understand their own emotions, the emotions of the people in the court, the lawyers, the parties, and that they need more guidance. So bench books, guidelines, etc. And in the paper, I've drawn an analogy with how lawyers in mediation also need that support and guidelines.
So Kathy, in your paper, would you be providing some model clauses that might go into the Law Council's document?
Well, what I've done is critique sections. So I haven't put the exact wording because I think that can, I think Bobette did at one point, but I thought it was a bit brave actually.
Yeah, it might preempt consultation.
But I do critique and say where I think it could fit.
Great.
Probably that's the part of the paper I need to develop a bit more.
So Lawrence, would you like to ask a question? You've heard from Kathy how influential your work has been in getting to this point.
It was terrific, Kathy. I really enjoyed the way you brought a lot of complexity to the surface. So I hope you don't mind if I sort of complicate it a bit, but I really like that. And just yesterday I had a classic case. I'm glad you referred to positive emotion. I had a classic case of negative emotion. In a Zoom mediation with and I find the high manifestation of emotion, quite rare. Although we know it's always there, it just may not be manifested. But this is a classic case of a lawyer just wanting to argue the law, the facts, and the evidence, which ties up on your point about it's almost a mimicry of the litigation process. But I do think there has been some cultural shift there. I just wondered if I could comment on a couple of things and end up on that last point you made about judges understanding emotions. And I know from work I've done at the National Judicial College is that there's certainly an enormous amount of interest here. And apart from that article by McHugh, there's the other excellent one late last year by Chief Justice of the Federal Court, which I think was really insightful to judicial thinking. And he refers to Ian McChrystal, who's one of my go-to gurus now, the English psychiatrist. And he also refers to Tyson Yunkaporta, who's stunning book on sand talk. but I'm just wondering, and I noted, Kathy, and you very wisely didn't talk about what emotion is. So well done on that, because we could get easily distracted on that. But I just wondered if I could throw this in and lead up to this question of understanding emotion. You know, what I'm reading more recently, from the neurosciences, is that, you know, what we call emotion is a complex, you know, combination of a whole lot of different factors. In fact, Kathy, you referred to it as having a cognitive aspect to it, you know, physical and a cognitive and so on. And I think that's right. And I'm wondering whether, as lawyers and dispute resolvers, we should think a bit about reframing the word emotion. And I'll put in a bit of suspense here in terms of how I think, you know, we may better portray it. But I think a lot of this comes from a book whose title I have entirely forgotten, which is arguing that, you know, the notion of emotion is so inconsistent, not only cross-culturally, which we know it is, but within different groups and even with individuals. And the whole idea that an emotion is like a fingerprint, which we can identify and say, you know, we might say to a client in mediation, so you were angry, and they say, no, I wasn't angry, I was frustrated, and we think we've solved something there, and that may be a good clue, because frustration is easier to deal with than anger, perhaps. But my understanding is, because of the strong cognitive component to emotion, you know, we used to always say it's all the limbic system, it's all the amygdala and so on. But my understanding from the more modern theories is that it's so closely linked with cognition, and that the underlying word there is belief. So, in other words, this literature is saying, look, an emotion is just a pleasant or an unpleasant feeling. It's really a feeling thing. And then what we do is, depending on our linguistic context, because you can't have an emotion without a label, without a word for it. And there's fascinating cross-cultural studies where, if in some cultures you don't have a word for an emotion, you can't express it in those terms. Whereas in other cultures, you may have 5 words for anger, you know, all of which are trying to identify something different. And so, particularly with your last point, which I really like, and I think judges should do it, but I just wondered to what extent we can understand emotion if we frame it as that, as this kind of, I'm not even sure anymore what we mean by emotion, other than a feeling to which we've attached a linguistic label, because then it's easier to manage, and which of course may be part of the reframing that you referred to. But I'm wondering if we shouldn't talk more about the underlying belief that attaches to an emotion, which is a very cognitive thing. And then we can take it out of a sort of theological frame and talk about what's, you know, there seems to be an underlying assumption here that you were poorly treated or whatever it is. So anyway, it's just a thought, but it was a terrific paper. Thanks so much.
Oh, I think you've opened up lots that we could talk about and debate. And I think the problem with this paper is, what do I leave out? I absolutely agree, because I thought very much about, do I do the neuroscience and it would have taken, this is already nearly 10,000 words. And so I made the call, if you like, particularly following Kathy Mack and Sharon Anlu's approach, where they tend not to go into all that in their writings for judges. But you're exactly right. It's linguistic. It differs in different cultures. But given to emotion now, the behavioural economists are talking about how emotion frames our decision making. The marketers use triggers for emotion around products, because they seem to be an effective way of asking people to buy or encouraging people to buy. The ways that the people in the various medical areas and not only the psychologists are now saying it affects so much of health and well-being. I would say that we need to consider it in mediation, even if what we're doing perhaps is only a first step. So it's a baby step approach by saying the ways that lawyers are practicing now predominantly, although they have moved forward in moving to a more collaborative problem-solving frame, those lawyers are arguably not allowing much emotional recognition and engagement. So I've used the term a lot of allowing and encouraging. And so looking at it from the perspective of lawyers, most contexts of practice would not readily make emotion part of the story. And the difference was those planning lawyers who really engaged with emotion in a very purposeful way because they saw it as assisting settlement. So that was the study that made me think of this paper and trying to see perhaps what we should be doing is providing more guidance to our legal profession about allowing and encouraging emotion and really linking that to what judges are now saying.
Yeah, this is something that we would love to talk about all afternoon, I think. In the interest of time, we will have to start to wrap up, but Margaret's got her hand up to say something. No, we'd love to hear from you, Margaret, and then I'll hand over to John to make final comments and conclude.
All I was going to say in relation to emotion, and this is probably a bit obvious, but it seems to me that the emotions that happened way back when then transfer into values and then are reflected as facts. So when you actually get to the mediation, the person is expressing firm views about facts and outcomes and needs, you know, practical needs. But I think often those 2 years ago were started as emotions, which has turned them into like tangible facts, but they're really not. And that seems to me to be a challenge in this process.
Yeah, so often we think of it as emotions showing what people value, their underlying interests and concerns.
Kathy, I think that was a wonderful paper. And as you were speaking, I was thinking about the ways in which not allowing emotions into the process particularly can impact on vulnerable parties and those who might not perhaps have the educational background or legal type skills that might be expected by some parties in a mediation room. So I'm sure that's something we should go into further if we have more time, and something that Rachel and I have touched on in our work on the mediation language game and the sort of hidden expectations that may structure behaviours in a mediation context.
And perhaps we could encourage people to keep this conversation going on the blog by responding when Kathy's presentation is posted, by putting in comments and having that conversation there as well, so that everyone can join in.
Absolutely.
I've read your paper, actually. That's a great one to include. I'll have a look at it again.
Thanks, Kathy. And of course, we could discuss these things a lot more, and we'll continue the conversation on the blog. But for the moment, in the interest of time, we should probably wrap things up. So all that remains, Kathy, is to thank you once again for presenting your paper, and I hope that we will see a lot of discussion about it online.
Oh, thank you very much. I appreciate it.